impounding any weapons at all?
No weapons at all. Clever people.
All right, back with me now to discuss this is criminal defense attorney Michael Sterling, and joining us now is criminal defense attorney Ashley McMahan. Ashley, what do you make of Detective Johnson?
Oh, goodness, I think the defense is doing an amazing job here because, as we all know, in the defense's case, it's all about what the prosecution didn't do.
Yeah.
It's all about poking holes in all of their evidence. And they're going through showing, hey, were you aware that he got the car detailed on a regular basis? No, we didn't bother to check that. Hey, did you find any weapons in the defendant's house? No, I didn't actually conduct that search. So, I mean, I think they're doing a really great job with this witness. And I don't think this detective is quite ready for these questions or was prepped adequately by the prosecution.
I agree. Michael, what do you make of the state trying to get out through this witness that Kellen Winslow was attempting to sell this Hummer?
Yeah, I don't even know if that's, I don't know how relevant or how helpful it is,
Yeah.
To the narrative they're trying to paint.
Well, what if they're trying to say, you know how you watch all these movies and the perpetrator, commits a crime in the car, and then they try to go and either burn it or try and sell it or clean it or run through a car wash, that kind of thing.
The time frame is the time frame hurts him significantly. I mean, It's not like he was rushing that day to try to hurry up and sell the car or set it on fire and collect insurance money or anything that's that radical. It seems like there's a measured attempt to potentially, sell a vehicle that maybe he wasn't using that frequently.
And he's an former NFL star, right? So he's probably running through a bunch of cars, is I guess Brian Watkins' point. But what do you make of again, going back to Detective Johnson saying, yeah, we saw the attempts made to sell this car to a dealer. He drove off in the Hummer. We didn't talk to him either.
I mean, exactly.
Right.
So we didn't bother to go through with our investigation. I guarantee you the defense attorneys are going to bring this up in their closing argument. They're going to say, look at all the things that they didn't bother to do because they only sought evidence when it was convenient to the narrative that they already were spinning for this case.
I agree.
It's never good when a defense attorney does a better investigation than the police officers.
Well, that's bad. But what this case did, just even starting out, even in opening statements, you had the prosecution make theirs, and then you had the defense attorney. So the prosecution had 65 minutes to make their opening statement. Then you had the defense attorney, Brian Watkins, make his in 8. And what he did was say, this is what the state didn't tell you. This is what the state didn't tell you. And it looked terrible because now he's putting a magnifying glass on these issues that probably weren't that big of a deal in the first place. But now the jurors are thinking, well, why is the state not telling us this, right? So, okay, so what do you make of the fact that he's bringing these photos of Winslow in cycling gear? Do you think that the jurors are connecting the dots here?
There's no question
Michael?
about it. I mean, it's a smart move by the prosecutors. They're not doing it directly, but they are subtly planting this image in the jurors' mind that it's not beyond the realm of possibility that this individual wore cycling gear, which connects to one of the Jane Doe's testimonies that a man rode up to her in cycling gear, exposed himself on his bicycle. So they want the jurors to know this is a professional, this is an individual who cycles regularly.
Yeah.
He's a professional cycler, and so they want to try to connect those dots.
But here's my problem with this, Ashley.
Yeah.
With Jane Doe number 3, she could not identify Winslow in a lineup in court. She admitted that culturally they don't look at people, Vietnamese, they don't look at people in the face, so she couldn't necessarily say who this person was. Mm-hmm. This case would never make it this far had it not been included with the other 4 cases.
Exactly.
So it seems as though, is it just me, but it seems as though the state is trying to come up with all the circumstantial evidence to make it plausible that he was the black man with tattoos with some cycling gear on a bike, through this evidence, through John Johnson.
Absolutely, and you couldn't be more right. It's all circumstantial evidence with Jane Doe number 3. So what they've got to do is, you hear it all the time on TV, oh, it's just circumstantial evidence. Well, circumstantial evidence always builds to basically, the inference that this could be direct, that this is who this is.
Yeah.
And I think with this particular victim or, whatever they're calling them, alleged victim at this point in time.
Complaining witness.
Complaining witness, yes, you're correct.
Defense attorneys complaining witness,
Yes.
prosecution's victims,
Victims,
right? All right,
yes.
so you guys are gonna stay with me. We're gonna talk some more about this, but a few weeks after Jane Doe number 3 accused Kellen Winslow, the second, of exposing himself, police searched his home. We'll hear what they found right after this quick break. Stay with Court TV, your front row seat to justice.
Kellen Winslow II, an NFL star.
You immediately knew that people were going to pay attention.
There are 5 different women who are accusing him of being a serial sex offender.
You will hear from each one.
He goes, if you don't do this, I'm going to kill you.
Winslow denies all charges and claims the women are just after his money.
This is a part of the story that is getting unusual, to say the least.
It's very hard for us to put ourselves in the criminal mind.
You're watching Court TV. I'm Yodite Tewolde. The prosecution in the Kellen Winslow trial called a series of witnesses Tuesday to testify about the crime scene investigation, including a search of Winslow's home. Brandy Silverthorne, a senior crime scene tech, took photos of items of interest, including a backpack, cycling clothes, and shoes. Let's listen to part of her testimony.
Showing you Court's Exhibit 49 for identification. It's been previously shown. Is this the photograph that you took of the overall area?
Yes, it is.
Showing you Court's Exhibit 51 for identification. Looking here, do you see 2 items that have been identified by placard that were located within the residence?
Yes.
Can you just describe for the jury where this is within the residence?
Yes. When you came in the front door to the residence, if you turned to the left, there was a dining area and a kitchen area to the left. This area is against the left wall of that area between the dining room and the kitchen.
And looking at the 2 items, can you see what the placards or what placards were used to differentiate them, beginning with the one on the left?
Yes, these 2 items were identified with placards D and E.
And in terms of the articles or the items that are directly next to the placard, what are those that are laying on the ground?
The item that was identified with placard number letter D is a blue backpack, and the item that is identified with placard letter E is a pair of shoes.
Showing you Court's Exhibit 52 for identification, does that have a slightly different perspective of the same 2 items?
Yes, this is just another location shot from a different angle.
I'm sorry, which number was that? That was 52, Your Honor.
Thank you.
And now showing Court's Exhibit 53 for identification, what does that show?
This is a close-up view of the item that was lettered E, and it's this pair of shoes.
Showing you now Court's Exhibit 54 for identification. What are we seeing here?
This is a view showing the blue backpack that was identified with letter D, and we are now going through the backpack to conduct an inventory of what is in the backpack.
And when you say we, are you still working with your law enforcement officer team?
Yes.
And do you see that the individual who's at least opening the backpack is wearing gloves?
Yes.
Is that standard protocol?
Yes.
And do you see that there is a sheet with handwritten notations that's to the right?
Yes.
What's that?
This is, we call it a receipt and inventory. It's a documentation of the items of evidence that were collected, and we document those items as we collect them.
And you can see that there are a number of placards with different letters associated with it. Were all of those being used in the collection of evidence that day at the Winslow residence?
Yes.
Showing you Court's Exhibit 55 for identification. We're still talking about the blue backpack that was item D, is that right?
That's correct.
And does that show the contents of the exterior zipper area?
Yes, it does.
Showing you Court's Exhibit 56 for identification. Is that another view of the contents of the backpack?
Yes.
And showing you Court's Exhibit 57 for identification. Is that the interior zipper area?
Yes.
And showing you Court's Exhibit 58 for identification. Is that the main compartment of the backpack?
Yes.
Now, showing you Court's Exhibit 59 for identification, does that have the contents of the backpack now laid out?
Yes.
Did that include each of these things, a garage door opener, a handheld garment, GPS device, things of that nature?
Yes.
Now showing you Court's Exhibit 60 for identification, is that item D in a close-up view?
Yes, it is.
Back with me now to discuss is criminal defense attorneys Ashley McMahan and Michael Sterling. All right, Ashley, blue backpack, look familiar?
Yes, it does. See, okay, if the defense counsel had gotten their wish and had all of these trials separated and done it with each individual Jane Doe, this would not be a slam dunk for the prosecution, Jane Doe number 3. But they've got to use these building blocks. This is one thing that Jane Doe number 3 did identify, and one thing that she recognized. She may have admitted that she didn't really look at him in the face, can't really identify who the defendant is, but she knows that blue backpack.
It seems like Jane Doe number 3 was able to identify things other than the perpetrator, and that's working to her favor, right, Michael?
Absolutely, yeah. When you start to, you have these identifying objects, it can help, especially when they're very specific to the individual.
Yeah.
And then you found them in separate locations and say, oh, she didn't see his face, but she recognized that backpack, she recognized those cycling clothes, she recognized tattoos, she recognized things that are associated with the defendant.
But that oh my God, but in isolation, you don't take a case to trial if you can't identify the perpetrator. You don't even know if he's in this room. Brian Watkins, in his opening statement, said, it isn't, Jane Doe number 3, you aren't going to hear her accusing Kellen Winslow of anything. It's actually law enforcement that's accusing him of this crime. And he's kind of right, but she's still able to establish that this happened to her. So far, it's looking pretty good for Jane Doe number 3. And I would have said a week ago, Jane Doe number 3 had the weakest case, right?
Yep.
Yeah.
I mean, the weakest case, but it seems like it's working in her favor because you have these crime tech folks coming in, testifying and bolstering what, Detective John Johnson said, or at least he got the photographs of Kellen Winslow, and he was in that cycling gear, wearing that blue backpack.
Yeah.
And now this individual's on the stand, and she's saying, here it is.
That's why the prosecution is moving so slowly through this and taking each piece of evidence, one at a time to build this whole picture for the jury, in their mind, and really, just like you said, bolstering Jane Doe number 3's opinion. And I agree with you. I didn't think they had any sort of case with her from the beginning.
Yeah. Michael, how do you attack this person on cross? Do you spend a whole bunch of time with her?
No, I don't think so. I mean, I think you attack her with the other individual's testimony. So you've got to sort of use their strategy against them. So if they're building up slowly, you say, well, let's talk about the other Jane Doe. Did she ever tell you that she could identify Kellen Winslow? Is this the only blue backpack that exists in the world?
Is this the only blue backpack that exists in the world?
Right.
I mean,
what's the most popular color of backpack sold? Blue, black, red, right? So you start to say, is it possible that there could be another, individual with a similar colored backpack?
Another black tattooed man with a blue backpack.
Was it dark blue or light blue or sky blue or turquoise? What color? You have to try and just tear it apart piece by piece.
Piece by piece. All right, don't go too far, guys. Police also searched and swabbed Winslow's car for DNA evidence. More testimony from the crime scene tech when CourtTV Live continues.
A guy who was very competitive. I mean, he played for 10 years in the NFL, had an immense amount of success, felt like he had it all.
Kellen Winslow Jr. pleaded not guilty to kidnapping 2 homeless women. The former NFL player reportedly lured them into his Hummer and raped them.
He's facing multiple life sentences.
We're talking about a kidnapping and a forcible rape of strangers, of older women.
Because I don't care who's going to watch, I'm going to kill you. I told him to stop.
Her credibility is suspect.
It's a money grab, unfortunately. That's the society we live in now.
The notoriety, his wealth and his fame, all of that is at risk now.
Any words today about court?
No, all the facts will come out.
I just thought he was going to shoot me or something. I don't know.
He knows walking in and out of courtroom, the eyes are on him.
To the people that know me out there, they know who I am. I'm an innocent guy. I'm an innocent man.
Welcome back. All right, before the break, we heard part of the direct examination of crime scene tech Brandy Silverthorne on cross. She was asked about the search of Winslow's vehicle, which did not turn up any blood or DNA from Jane Doe number 1 or Jane Doe number 2.
How long you been employed in your position?
Well, I've been with the Sheriff's Department since 2011, but I've been doing this work specifically between the Sheriff's Department and the San Diego Police Department since 2007. So about 12 years.
12 years, it's fair for me to say you've been to a lot of crime scenes.
That's correct.
And you've taken a lot of, you took courses on blood spatter and blood stain analysis.
Well, I have had courses in bloodstain pattern documentation. I have had those training classes.
And you've been to crime scenes which have some have a small amount of blood, others have an enormous amount of blood, correct?
That's correct.
And you would agree with me that blood is one of those items which, that there can be minute remnants or large puddles, essentially, right?
Correct.
And sometimes you can detect blood which isn't actually visible to the naked eye.
That's correct.
There's blood can travel through the air to all different parts of an area, correct?
Correct.
In other words, so if somebody were trying to clean up blood, they might be cleaning up in an area where they thought the blood was, but it could actually have traveled, it could be arterial spread, it could be fragments which go in all different directions. Correct?
Yes, somebody could try to clean up blood in one area and not realize that there is blood in another area and potentially miss that area.
In this vehicle, did you locate any items which might have some type of evidentiary value regarding blood?
So in this case, I was working with a criminalist at the time, and so he did an examination of the vehicle for visible blood.
Okay. But
And
you weren't part of this?
I was present during the time that he did it.
Okay. Was any blood found?
So he found 2 areas that, I'm sorry, one area that reacted with the chemical and luminesced or glowed, that blue color, and so we sampled from that area.
Okay, and what criminalist was this?
That was criminalist Darren Bowles.
So who would do the analysis of that?
So I collected the stains, I collected the swabs that criminalist Bowles collected, and then I impound those with property and evidence. The lab request for the analysis of that is then assigned by a DNA supervisor.
Okay, so you don't know the outcome of that particular finding?
I do not.
So that would take another individual to come in and tell this jury whether or not there was actually blood found there or if it was just a dark substance.
That's correct.
And that happens, do you agree?
Yes, I have seen that happen.
And by that meaning it not be blood, but just some other
That's correct.
substance.
Yes.
All right, so one of the other things you did was you swabbed for DNA inside the vehicle.
That's correct.
Explain to the jury what you did as far as, first of all, what is swabbing for DNA as far as your role goes?
Okay. Swabbing for DNA means that I take a sterile swab and some distilled water. I get the swab just a little bit wet, a drop or 2 of the distilled water. And then I swab an area that I'm interested in for what we call contact or touch DNA, meaning somebody handled that area or touched that area. I take that wet swab and I really swab the area such as a door handle, a seatbelt buckle, something of that nature. And then I place that swab, it has a plastic cap on it. I close the plastic cap, put it into an envelope, and then again it gets inventoried, written on my report, and submitted to property and evidence.
Okay, so correct me if I'm wrong, but there are various ways that you can get a DNA sample, essentially?
I'm not sure I understand.
Bad question. In other words, there are several ways to leave DNA. How's that?
Yes, that's correct.
So you can get DNA through blood.
Yes.
Hair follicles.
If the root is present, we can get nuclear DNA from hair.
You can get it from skin.
Yes.
Skin samples. I mean, it's scrapings, things like that.
Yes.
And you talked about contact DNA also. It's just somebody touching an area, right?
Correct.
Okay, so, and that type of DNA that we described, a lot of it is not visible to the naked eye. You would agree?
Yes, that's correct.
Still with me now to discuss our criminal defense attorneys, Ashley McMahan and Michael Sterling. Okay, guys, they're talking about DNA swabbing of the vehicle. belonging to Kellen Winslow. Does that all matter when, and maybe I'm missing it, but Michael, does that matter if the defense is arguing consensual sex with Jane Doe 1 and 2?
Yeah, no, I don't think it matters if that's going to be their argument that there was consensual sex. I don't think that matters. I don't know why they would go through the exercise of really pointing out that there was no DNA in the car if they're going to ultimately make the argument that it was consensual sex, because that won't matter. You're basically admitting that they were in the car.
So let's just say this: Detective John Johnson testified that Kellen Winslow told him, when interviewing him, that it was consensual sex with Jane Doe 1 and 2. So that's done. So his defense is already out there without having to put Kellen Winslow on the stand. John Johnson said that's what he said. So he's arguing that. So again, DNA.
Yeah, you go ahead and make the concession and spare the jurors, the having to go through the entire exercise of listening to this, really scientific DNA evidence. You spare them that and say, look, we're willing to make the concession. They were in the car. And maybe you even try to work out a deal with prosecutors to say you don't have to bring up all this DNA analysis. We're willing to stipulate that they were in his vehicle.
Well, maybe not stipulate to Jane Doe number 1.
Yeah, not Jane Doe number 1, I'm sorry.
Okay.
Yeah.
So Jane Doe number 1, she stated that she was bleeding everywhere, after the alleged rape occurred. In fact, before I ask you the question, let's go ahead and play that clip of Jane Doe number 1 on cross-examination describing those bloody pants.
I just want to see this. If you say there was blood all over the place, it was all over your pants too, right?
Right.
Before you washed them?
Right.
So you're walking around downtown, so you're just going about your day for hours with these pants with blood all over them?
Yes.
Nobody stopped you and said, are you okay? Nothing?
No.
None of your friends in the streets said, hey, what happened to you?
No.
Okay, so Ashley, you heard Jane Doe number 1 basically saying, I had blood all over my pants after Kellen Winslow kicked me out of the vehicle. I'm walking in downtown San Diego trying to find a place to basically clean up. And and you hear the defense attorney saying, nobody stopped you, seeing all this blood. So again, connect the dots for our viewers. Why this line of questioning from Mark Carlos about the DNA in the car, about no blood being found?
I mean, what she is describing during her cross-examination is that she's, basically a murder scene almost, that there's blood everywhere. And what you saw with the previous detective, what defense counsel did on cross-examination was very interesting. He said, you can't get rid of evidence or DNA like blood, luminol, and he mentioned that. It always shows up. It doesn't matter how well you get the car detailed. And they're chipping away at that, saying, her testimony is just not consistent with the actual physical evidence in this case. So I really like what they're doing here. I think it's interesting.
Michael.
Yeah, no, I completely agree. I think you want to point out that it was impossible for there to be all this blood. Like, it's impossible to clean up. Blood's impossible to clean up. It would have been at least some residue of blood somewhere if they did a detailed analysis of the vehicle. And to Ashley's point, I think they're doing a great job of just chipping away at that.
Even if he washes and details his car regularly, I mean, blood, no?
No, you can always, and look, you can miss it. And as the defense attorney is pointing out, there's DNA and things that you just can't see with the naked eye that, a detective with the right equipment can pick up on.
Yeah. Good point. Excellent point. All right. A big day of crucial testimony coming up in the rape trial of Kellen Winslow II. Jurors will hear from the daughter of Jane Doe number 1 and also expected to take the stand, Jane Doe number 4, the woman who claims Winslow II raped her when they were both teenagers. Stay with CourtTV Live. Oh, wait.
I'm Seema Iyer. Some people say I'm tough. Maybe it's because I was a prosecutor in the Bronx. I may have earned it as a lawyer representing the NYPD. Or it's because of my expertise in forensic science. Sure, some people call me tough, but on CourtTV, they call me the Queen of Crime.
The all-new CourtTV, your front row seat to justice.
Well, I imagine your investigator asked her about what she watched and what she saw, and I don't know of any case or any statutory authority that will say that this witness is completely barred from testifying. So she will be able to testify. And Mr. Carlos, you can cross-examine her as much as you want as to what she saw, what talking heads she listened to, and what she heard her mother say.
Today, a surprising witness takes the stand in the Kellen Winslow trial over the defense's objections. The judge ruled the jury will hear testimony from Jane Doe No. 1's daughter, who claims to have corroborating evidence that her mother was raped by the NFL star. Will Jane Doe 1's daughter help the prosecution's case? We'll see later today as our gavel-to-gavel coverage begins now. Good morning, this is CourtTV Live. I'm Yodite Tewolde. A big day of testimony in the Kellen Winslow rape trial begins in just 2 hours. We're expecting to hear from Jane Doe No. 1's daughter after the judge made a key ruling in favor of the prosecution. And Jane Doe No. 4, who claims she was raped by Winslow in 2003, will take the stand. Let's head back out to San Diego County Courthouse and check in with our CourtTV crime and justice reporter, Ted Rowlands. Ted, please tell our viewers what we can expect at 9 a.m. your time.
Well, it's going to be a big day, Yodi. Good morning. We're going to hear from Jane Doe No. 1's daughter, as you said, and what she brings to this case will be pivotal because I think most people who have been watching this case look at Jane Doe No. 1 and say, she does need a little help in terms of her story. And this is an opportunity that just fell on the prosecution's lap. She literally called the DA's office and said, hey, I'm watching Court TV. That's my mother on the stand, and I've got some information. So she's going to come in and say she saw bloody pants, those white leather pants that Jane Doe No. 1 talked about from the night of the alleged assault. And she says that her mother at one point told her to beware that there is an NFL player out there raping women. Two things that could bolster Jane Doe No. 1's story because, of course, it says that the pants indeed were bloody. Now, what details she has, we don't know. The bottom line is Dan Owens interviewed her and wants her on the stand, and Judge Bowman said she can come in, but be prepared for cross-examination.
And can you tell us what the defense's argument was against having her take the stand?
Well, simply, I mean, you don't allow witnesses to watch an entire trial and then come on and take the stand with an agenda, and that's basically what could happen here because Jane Doe No. 1's daughter is watching it on Court TV. That came out in court last week, that this is the reason that she saw her mother, because she's watching the entire trial. So the reason you don't want witnesses to see testimony before they take the stand is obvious. In this case, this person will have seen all of this testimony. So Judge Bowman says, all right, listen, I'm not keeping her out, but I'm going to allow you the opportunity to cross-examine her vigorously. We'll see how it all plays out. At the end of the day, this may not help the prosecution that much. We'll just have to wait and see what she has to say and the way she says it.
And Ted, what about Jane Doe No. 4? We're expecting to hear from her, hopefully her husband, her friend, and ex-boyfriend all today?
It really depends on Jane Doe No. 1's daughter and Jane Doe No. 4 in terms of the length of her testimony. Jane Doe No. 4's story is going to take some time to tell this jury because it happened so long ago. This, to remind our viewers, this is the woman that came forward after seeing Kellen Winslow in the news being accused of rape. She called the DA's office and said, hey, this happened to me. This happened to me when I was 17 years old and he was 19 years old. So she tells a different story. And it's a story that happened years ago, so the jury is really going to have to compartmentalize her testimony, and as you mentioned, these other witnesses that are going to come on and corroborate what she had to say are very important for Jane Doe No. 1's story and for this jury to believe her.
And Ted, are we going to hear from Jane Doe No. 4's husband through a video because we thought at some point he would be deployed, or are we going to see him live in court giving that testimony?
We're expecting to see him live in court. That was one of the stipulations made, that they put his testimony on video because he is in the armed services and he could be deployed potentially. So what they did is sort of a safeguard. If he's not around, they could play this video of the interview of Jane Doe number 4's husband if he's unavailable. But we believe he will be available, and we believe that he will be live in person, sitting on the witness stand when he takes the stand, possibly later today, depending on timing.
All right, Ted Rollins in San Diego. Thank you so much, my friend. Okay, so the judge decided to allow Jane Doe number 1's daughter to testify over the objection of Winslow's defense team. A hearing and the judge's ruling happened outside the presence of the jury.
Okay, well, I imagine your investigator asked her about what she watched and what she saw, and I don't know of any case or any statutory authority that would say that this witness is completely barred from testifying. So she will be able to testify. And Mr. Carlos, you can cross-examine her as much as you want as to what she saw, what talking heads she listened to, and what she heard her mother say while she was watching TV. I am not restricting you in any way in that cross-examination. I just don't see any authority for barring her.
I understand the court's ruling, but the record's clear. I don't see it any different from somebody sitting in the audience, right, and watching testimony and then saying, oh, by the way, I didn't tell you this. It's the same thing because they're watching it at home.
My understanding is, Mr. Owens, you want to bring her in to establish that she saw the bloody pants and also to establish that the complaint was made the day after the alleged rape, correct?
Yes.
All right, now would come in under a fresh complaint. It's a non-statutory exception. It's not admitted for the truth, but just merely the fact that it was made, identifying the perpetrator, and just the nature of the attack. So that would be allowed. Now the next question would be whether or not anything Jane Doe told her daughter comes in as an exception to the hearsay rule, either as a prior consistent statement or a prior inconsistent statement, and we can handle that as we go along. We don't need to air the whole thing out beforehand.
Back with me now to discuss are criminal defense attorneys Ashley McMahan and Michael Sterling. You know what I hate the most, you guys? I hate when, say, the prosecution says something and the defense attorneys, object and then ask the judge to ask the jury to disregard what they just heard, because you can't unhear what you just heard. And this whole thing of not admitting something for the truth of the matter asserted, how do you think the jury is going to take this information from Jane Doe number 1's daughter, who's going to testify to corroborate what her mom said, but it's not supposed to be admitted for the truth of the matter asserted? We talked about this, Michael, in the last hour. Ashley, give me your thoughts about what the judge is ruling about this and allowing Jane Doe number 1's daughter to testify.
Well, first of all, give me a break. That's exactly what the jury is going to take this information as, and we all know it.
Yeah.
So I really think, and we were just discussing this during the break, I do think that Jane Doe number 1's daughter's testimony is actually going to backfire for the prosecution.
I do too.
I mean, if I'm defense counsel, in my closing argument, statement number 1, look, Jane Doe number 1 was so unconvincing and their case with her was so weak that they had to bring in her daughter to corroborate her testimony midway through the trial after she had watched it on CourtTV.
All of it.
All of it.
Watched all of it, yes. And she got to see what it is her mom said about those pants, about what her mom alleged with Kellen Winslow, and like you said, Michael, fashion her testimony. Yeah. Not to say that this didn't happen. Maybe it did. But what do you think it says to the jury about the state, not necessarily dotting all their I's and crossing all their T's?
Yeah, I mean, I think where was the state at? It also feeds into the defense's argument that you all didn't do your job in terms of offering a complete investigation.
Yeah.
Then you would have known that there was a daughter present in the home. You would have known to go and interview that individual to find out if she had any relevant information. And instead, you failed to do that and get a surprise phone call in the middle of the trial saying that I've got some information to offer you. Well, where were your detectives at? Why weren't they doing their job? Why weren't they, why didn't they go and interview this individual, when you all first, started to investigate this case? Mm-hmm. And so I think it feeds into the defense's overall narrative that you all did a incomplete investigation and you all failed to do your job. They failed to do their job as detectives to make sure they were getting all the relevant evidence, and then they start to feed into their arguments about reasonable doubt.
Okay, so so they can pick at the state not doing their job, but can they pick on Jane Doe number one never ever saying on the stand. This was a moment of contention on cross for Jane Doe number one. The Mark Carlos was like, you had your cell phone the entire time. When this was over and Kellen Winslow was gone in his car, why didn't you get on the phone and call 911? Why didn't you get on the phone and call your daughter? Why didn't you call anybody? Wasn't that the moment for her to say, actually, I did call somebody. Actually, I did tell somebody about this. She didn't do that. Is that what you mean by backfiring on her?
Absolutely. I mean, this is exactly what juries don't like to hear. They're like, okay, so she had behavior that was inconsistent with what a rational human being would have done after this alleged incident occurred to her. And I think this is exactly what the defense is going to hone in on for this particular Jane Doe.
Michael, it's almost like you either have to call Jane Doe number one a liar or her daughter a liar. And do y'all follow me?
Or both of them.
or both, but they didn't really, get on the same page.
Right.
Because Jane Doe number one is going to have to say, I forgot. Unless she says I forgot and I didn't say, to you all when I was testifying that I did actually tell my daughter, which actually makes her really sound kind of out there, because how do you not, when this is literally being hammered in that you didn't tell anybody about this alleged rape? But then if she says, oh, I didn't tell my daughter, then her daughter looks bad.
Yeah.
So on cross-examination, how would you attack daughter?
I would really start by essentially pointing out how she got there today, like how she got to the testimony. So I really would want to attack her credibility at the very beginning before I even start getting to the substance of what she knew or didn't know.
Yeah.
I would really start with, you hadn't been investigated by anybody. You were watching this on Court TV.
Yeah.
You wanted to be here. You wanted to be on Court TV. You wanted,
Well, what about the dynamics of her relationship with her mom? That has to come into question.
I think you've got to lay a foundation and figure out, because I don't know if the defense team, what they did in their interview and whether they know what the relationship is, but they're going to have to figure out, lay some sort of foundation about, what is the relationship? Are you and your mom very close? Are y'all estranged? Do y'all talk every day? How often do y'all talk? Did you know she was testifying before this? Did you know what the case was about? I think you've got to sort of lay a foundation. So either they're very close and they talk every day and she was familiar with the testimony, and then and that's when you really start to eat at her credibility.
Ashley, on its face though, when I hear that her daughter saw her mom testifying about this on TV, that tells me you aren't that close to your mother.
Exactly. And so here's where you ask, if you are close, how come you weren't in the courtroom supporting your mother?
Right.
You would have known about this incident. You would have known she was testifying this day. You wouldn't have just watched her on TV. And then if you're not close and you're estranged, how come you're able to find evidence midway through a trial?
Those pants.
Yes.
You remember those pants.
The smoking gun or the smoking pants in this case.
Well, do you think that with her testifying, it could actually open up the door to other things that maybe cross-examination didn't get into with Jane Doe number one?
Absolutely. I mean, when I was a prosecutor, I had an airtight case. I sort of knew what my witnesses were going to say.
Yeah.
It's hard to bring a witness at the last minute. You don't know what the defense is going to cross-examine her on. You don't know what she's going to say. You don't know what other things she might say to harm your case. She could blow up their entire case, and that's a very difficult thing to do. You don't want to put a witness on the stand and you don't know what they're capable of.
You're absolutely right, but I don't know if she can make Jane Doe number one's case much worse, but we'll see. All right, the defense scored a victory over evidence relating to Jane Doe number two. We'll have details on that right after this quick break. Welcome back. The defense in Kellen Winslow's rape trial did have one key win on Tuesday. The judge ruled they will be allowed to admit evidence that Jane Doe number two had consensual sex 2 days before Winslow allegedly raped her. Let's listen to that hearing.
Prior to taking the bench, counsel in the court had an unreported chambers conference because it dealt with Mr. Palermo's testimony in the presence of I think in the exam there was some semen in it that was not the defendant's, and according to her and what she told the SART exam nurse, Miss Williams, that she had consensual sex with her boyfriend 3 days earlier.
That's correct.
And the defense wanted to go into that at this point, and that was the subject of the motion that was filed this morning. And I have taken time over the lunch hour to research it. I've been looking at a case up here while on the bench, but I haven't had time to fully delve into it and research it thoroughly, but the court's research so far, based on People versus Fontana at 49 Cal 4th 351, certainly suggests that in that case it's almost exactly like this one. And I think that the defense wants the evidence. Who's handling this? Is it Mr. Watkins?
Yes, Your Honor.
Okay, so Mr. Watkins, I think it's your position then that given the testimony of the nurse, Ms. Williams, that there was some redness on her vaginal examination, that could have been the result of consensual sex she had with her boyfriend 3 days earlier, correct?
The consensual sex she had, I don't know if that was with her boyfriend, but
Well, I think isn't that?
it's not what the sergeant's exam says.
Well, that's not what she told the sergeant nurse, but it was her, I think through the other evidence, it was her boyfriend. Is that correct, Mr. Owens?
It was a consensual partner that she engaged in sex on May 11th.
Okay, and the offense date for this was May 13th. So I think the defense wants to establish the fact that she had consensual sex 2 days earlier, and that could explain why there was some redness on the vaginal examination, correct?
Correct.
All right. And People versus Fontana addressed that same issue, and the California Supreme Court held that the defendant was entitled to have a hearing on the victim's prior sexual conduct as an alternative explanation for the injuries that the victim suffered. So it appears as though it is likely to come in under People versus Fontana, all right? However, the Supreme Court also stated that you have to comply with Evidence Code Section 782 because of the rape shield statutes, and the Supreme Court stated in their opinion, and I'll read directly from it, the legislature's purpose in crafting these limitations is manifest and requires a valid determination that victims of sex-related offenses deserve heightened protection against surprise, harassment, and unnecessary invasions of privacy. By affording victims protection in most instances, these provisions also encourage victims of sex-related offenses to participate in legal proceedings against alleged offenders. So the court can't ignore the rape shield law and not force you to go through the proper procedure. I think that based on what I've heard, it's probably going to be allowed. And I've given some thought to, we have to have a hearing after you file your affidavit in which you state your offer of proof. And we have had a hearing of sorts in the form of a jury trial where I've actually heard the testimony of the witnesses, and I've heard all the evidence. So but I cannot ignore the requirements under Evidence Code Section 782. So if you want to pursue this path, you have to file the affidavit. And I'm not convinced by the argument that 782 doesn't apply, because the Supreme Court, under facts almost identical to this, said 782 does apply. So I would recommend that you file your affidavit tomorrow morning, and then we will see where we go. But as we discussed in chambers, the next question is, how does this come in? Because what Jane Doe number 2 told the nurse is hearsay. All right, that means you have to bring Jane Doe 2 back in unless all of you get together and reach some sort of stipulation that would satisfy the need that you have to establish an alternate explanation for the vaginal redness. All right, so maybe you guys can put your heads together and come up with something, but based on Fontana, it's provides firm direction for the court in how to rule on this issue.
Exactly.
So, yes.
What I would say is, if the court is inclined to allow questioning in this area based on Fontana, and then the defense can propose a stipulation to the people that would address their concerns, then the people would include the information that was shared by Jane Doe 2 to the SART nurse. I think that we might be able to reach a stipulation rather than having to recall a witness, whether it be Ms. Williams or Jane Doe 2. The other thing that I would say is that the defense was framing it in context of wanting to discuss the redness that was found vaginally. There was also redness found anally, and there is no statement whatsoever that that Jane Doe 2 engaged in any anal penetrative act with a consensual partner. So that would have to be included within the stipulation as well.
Okay, well, I'll allow this. I mean, the stipulation requires the agreement of both parties. So if both parties can agree to it, fine. If not, file your affidavit. We'll have the hearing based, and I will consider all the evidence that the court has heard so far, and based on Fontana, I think you know what the ruling's going to be. So,
can I, just so the record's clear, we're referring this refers to a statement made. I wanted to cross-examine the SART nurse regarding a statement the patient made to the SART nurse for the basis of her opinion. The question is, it's number 5 on page 2 of 10. It says, has the patient had any penile vaginal penetration contact within the past 5 days? They mark yes. And its last occurrence, 5/11/218. And did the ejaculation occur inside the vagina? Yes. Was a condom used? No. That was the only area of inquiry on my part, and it had to do with the redness and the vaginal area. Nothing had to do with any anal activity. Just this particular statement.
right, and that's still hearsay. Now you can say that, well, it comes into because it was helping her form her opinion, but under People versus Sanchez, any case-specific facts cannot be brought out through an expert. So,
but this nurse is not testifying as to an ultimate cause. She's basically giving her opinion. She's giving her opinion, but she's also discussing her evaluation of this individual. And by her own testimony, all patient history is relevant to her determination as to what her findings are. And I think that was fair game.
okay, well, regardless of the source, whether it's through the Nurse Williams or through Jane Doe number 2, it still brings up prior sexual acts of the alleged victim, and we have to comply with Evidence Code Section 782. So I think tomorrow morning we'll probably have an affidavit and or a stipulation. We can proceed one way or the other, but Fontana dictates the outcome in this case, and it dictates that we follow the procedures that have been put into place to protect sexual assault victims. All right? So we will see everybody back here tomorrow morning at 9. We're going to start with Jane Doe number 1's daughter first, correct?
Yes, Your Honor, and I did want to address that based
Okay.
on our conversations. She would be the next witness. We will have her available to begin testimony at 9 o'clock. As it relates to the media's, the orders that the court has issued related to the media, you previously ordered that that none of the identified victims or their spouses may be shown. I would request that the daughter, given the fact that she is a close familial relative of Jane Doe 1, that her image not be shown either, so that we can protect the confidentiality and anonymity of Jane Doe 1.
Right. Of course.
She would be able to testify under her true name, given that it is a surname that's different from Jane Doe 1.
All right, so I will use her true name, but the whole purpose of not allowing any images of the victims' faces to be photographed or broadcast is to protect the anonymity of the alleged victims. And if we show her daughter, then people will be able to figure out who she is. So I'm going to order, I'll amend all the media orders for still and motion picture coverage that you not show the faces of the of Jane Doe 1's daughter.
Back with me now to discuss all of that are criminal defense attorneys Ashley McMahan and Michael Sterling. And joining us right from San Diego is Gretchen Van Holmes. All right, I'm going to start with you, Michael, in the studio, because you were shaking your head, and so was Ashley, when the judge was talking about having some sort of a stipulation with the defense and the prosecution agreeing to something in order to avoid having to call back Jane Doe number 2 and maybe even the nurse, but you were shaking your head adamantly like, absolutely not, no stipulation. Why?
That's not the type of evidence you want to have a stipulation for.
Yeah.
You want the jury to hear exactly what that individual, what Jane Doe number 2 said to the nurse. You want to bring it out in a fashion that helps draw your narrative, and the stipulation just doesn't have the same effect as live testimony. And so, and then you add to that stipulation that the prosecutors want to make some sort of conditional amendments to it where they say, well, yeah, but it didn't happen this way, it didn't happen that way. They're not going to agree to it. They're going to have to fight that out in court. You're going to want to bring your evidence out and let the prosecutors bring theirs out, but they're not going to agree to that stipulation.
But when you talk about the effect of having live testimony from essentially the horse's mouth, is that a good thing, though, Ashley, considering Jane Doe number 2 was she was giving Mark Carlos a run for his money. She was a good witness for the state. They don't want to bring her back and remind jurors how good and credible she was.
Yes, so the defense is going to want to bring back the nurse, and absolutely not Jane Doe 2, and the prosecution is going to want the opposite, so I just don't see how you can let Jane Doe number 2 come back. She was such an amazing witness,
I think that's what the court was essentially, that's what they were trying to, make clear to the judge is we want the nurse to come back. She can provide this information. It's an exception to the hearsay rule. We believe it can come in through the nurse, so we don't have to bring back her, and they can be nice by doing it. Oh, we don't want to bring back a victim of this incident. Let's bring back the nurse.
Right. Gretchen in San Diego, stipulation, no stipulation, what do you think?
Well, I've tried a lot of cases with Mark Carlos, and if, as you indicate, the second witness, the Jane Doe, is that credible, he might want to just get that stipulation out. That seems to be maybe the most prudent way to go here.
Well, okay, so you actually tried cases with Mark Carlos.
Oh, yes, I've tried sex cases with him, all sorts of cases. We've tried a case up here was called the Asian Male Smoker Series, in which there was a man raping some of the college and grad school women on campus at UCSD.
Well, let me put this Jane Doe number 1's daughter on the stand issue on hold for a second, since you actually have tried cases with Mark Carlos. He's been the one primarily cross-examining the Jane Does in this trial. I'm assuming he's going to be continuing that, and he's going to cross-examine Jane Doe number 4, who we're expecting to hear from. What do you think of his style of cross-examining? I think he's a brilliant attorney. I don't necessarily agree with his technique. What do you think? What do you perceive his style to be? And is it resonating with the jurors?
Well, he is a very aggressive style. He has a very aggressive style of cross-examination. He is convinced that the witnesses are lying. You can tell by his tone how he goes after them. And that works really well in lots of cases. In some cases, you have to be a little bit more sympathetic to victim witnesses. I think that's why they have Emily there, so that she will be maybe a more sympathetic cross-examiner if they need that style. But make no mistake, they're going at this case angry, upset that these people will come forward with false accusations, or cases of mistaken identity in the case of the Vietnamese neighbor. Mm-hmm. That there was some other African-American male who did this act, shorter, as she had described, and this was not their client and just got swept into this case as part of an allegation against our client.
Okay, Michael, he has this aggressive way of cross-examining, but he does not want it with Jane Doe number 2 again. I'm telling you, she was giving him a run for his money again. There was a moment in cross-examination where he was around Kellen Winslow, and she said, that's inappropriate. And she kept saying that. He goes, what's inappropriate? And she goes, you're making me look at my rapist. I mean, wow. She is doing the job of the state without them even having to intervene.
Listen, I've got an aggressive style of cross-examination. I think a lot of criminal defense lawyers do, but the best criminal defense lawyers know how to adapt their style depending on the jurors who are really your target audience, and obviously who you're cross-examining. So, I think that sometimes you do have to take a step back and be a little sympathetic, because even if you believe vigorously that your client is being falsely accused, you do have someone on the stand telling a very traumatic story about what they experienced. And your job is to, try to defend your client to the best of your ability. You may want to adapt your style a little bit to make sure that although you're defending your client, you're still demonstrating some sympathy and some empathy, so that the jurors don't start to dislike the lawyer,
Right.
and then you've got them, taking it out on your client.
Well, Ashley, quickly, what do you? It's one thing to cross-examine one of the Jane Does about the incident that they're alleging happened, but now we're getting into issues of, what the rape shield laws are there to protect, right? So now they're going to try and get into Jane Doe number 2's consensual sex partner she had 3 days before. She can have sex with anybody she wants. So is this sort of a dangerous line to kind of, walk with the jurors, given the fact that he kind of comes off insensitive?
He absolutely comes off insensitive in this, but I think it's really the only way that you can explain, because the prosecution is going to make such a big deal about the bruising, the redness, and this is a good way for the defense to explain, hey, look, she had consensual sex with someone else, and that's possibly why there was bruising or redness.
Mm-hmm. Good point. All right, so my guests are going to be staying with me. Don't go too far. The defense fights hard to keep out evidence that investigators say they found on Kellen Winslow's cell phone. That's coming up when Court TV Live continues. You're watching Court TV Live. I'm Yodite Tewolde. During an analysis of the defendant's laptop and cell phone, police found an app that cyclists use to track their routes and distances. Screenshots from the Strava app suggest Winslow was outside Jane Doe number 3's house the day before and the day she claims he exposed himself. The defense argued that to exclude the data, but the prosecution wants the jury to hear about this evidence. Let's watch.
Does the record show that Mr. Winslow was riding his bike on May 24th, 2018, around the time that's alleged for count 6?
Yes, Your Honor, it shows that he began a ride at 3:26 p.m. and the ride origin is just approximately one house away from where the victim stated this occurred, and she stated, as she testified, that it happened around 3:30 p.m.
We don't know how this Strava app works. And the proper person to authenticate how the records are generated would be a custodian of record or a qualified witness from Strava. The people contacted Strava and served them with a search warrant, and in reply, the representative from Strava said that they were completely unable to locate any records owing to Mr. Winslow on any information that was provided. So those records don't exist through Strava. And so we still can't authenticate those records.
Joining me now is my colleague and friend, the brilliant Julie Grant.
Oh, thanks, Yodite.
Julie, Strava app, never heard of it,
Right.
but apparently everybody uses it if you're a cyclist.
Right. I had to look it up yesterday, too.
I had no idea. But okay, so what do you make of the judge allowing the state to get this information that is damning for the defense, that places Kellen Winslow on his bike the day before and the day of the alleged occurrence that Jane Doe number 3 says took place?
Right. This was really a tough call, and the judge allowed them to lay the foundation and authenticate these images through that witness, through the computer forensic examiner. However, I think defense counsel should have been objecting with every single question there. We know outside of the presence of the jury, they had a discussion and they had arguments back and forth before the judge, but I think they still should have got up and objected. I think they would have won. I think although that witness certainly was qualified as a computer expert and had lots of experience with forensic analysis, she wasn't an expert on the Strava app. But once it's in, and as you pointed out, you're right, very damaging for the defense. And I think their argument is going to have to be, well, these two were neighbors. Jane Doe number 3 and Kellen Winslow II were neighbors. So when you bicycle, you're going to bicycle in your own neighborhood. So it's not dispositive. It's damaging, very damaging, but not dispositive.
It's damaging when you have Jane Doe number 3 basically saying, I can identify and talk about everything other than what the perpetrator looked like.
Right.
I mean, it is helping her case get stronger. And last week, you couldn't convince me that this woman's case was strong at all. It was the weakest one so far, right?
Right.
Okay, so this places him outside her house the day before and the day of. This witness that they're trying to get this information out of is an expert with regards to Strava, only being that she has the Strava app. Do you think this is something they can appeal? And tell us why you think they should have objected in terms of the jury. What do you think that would have communicated to them?
Exactly. I think it would communicate to the jury that something's wrong here. This shouldn't be coming in.
Yeah.
And I think that they do need to preserve that record for appeal. When in doubt, put it on the record. Put it on the record and make that objection. And I think if they would have kept objecting, number one, they would have disrupted the flow of what was going on there in that examination. Number two, been able to voice those arguments perhaps in front of the jury and let them get a little bit of a listen to, oh, wait a second, she's not an expert in what she's talking about. So I just think they really should have kept objecting, and maybe they would have had a better shot of not having it get to that point where she's testifying about that evidence, because really that's what the prosecution is going to hang their hat on, that digital evidence, because they lack the identification, as you said.
Ooh, so hard. Okay, switching gears, Jane Doe number 1, her daughter is expected to testify at 9 o'clock when court starts back up today.
Correct.
And Jane Doe number 1 needed some help. She also had issues identifying Kellen Winslow. But now you have the daughter coming in, and she is going to be testifying and somewhat corroborating what her mom's account was. Don't we invoke the rule for a reason? I mean, this woman could have been in the courtroom listening to testimony and fashioning now her testimony to go along with what her mother is saying.
Exactly.
How do you think that's going to reconcile with the fact that Jane Doe number 1 didn't do so well? Wouldn't the jury, because we just talked about Jane Doe number 2 on break, about whether she should come back and remind the jurors of how credible she is.
Right.
Does the state want to remind the jury how bad Jane Doe number 1's testimony was, because daughter could open up other doors that maybe cross-examination didn't get into, right?
That's a really great point, Yodite. Right. I mean, she could, and who knows what roads this may take us down. Right. I mean, who knows what she's going to say. And you're absolutely right. I think that the defense argument was that she had an opportunity to watch her mother's testimony on Court TV, see what her mother said. And you know so well from having been a prosecutor, a judge, a defense attorney, witnesses are going to be excluded for that reason, so that they can't fashion their testimony based on what someone else has said. And so that's problematic, number one. Defense has raised it, which is great. I mean, they're definitely making a record here, and the judge's resolution is, well, I'll give you a lot of latitude on cross. But is that enough of a remedy? Don't know. Don't know. And who knows if she's going to be a good. This could be very beneficial to the prosecution. I would imagine they think it will be, or else they wouldn't be calling her. Or, I mean, it could blow up and go poorly. As you said, who knows if she's going to hold up on cross. And
she's subject to be recalled, and we don't want to have Jane Doe take the stand again. That's just not what the state needs to do. Okay, so another ruling the judge made yesterday was that the defense will be able to get, possibly, they're supposed to file some sort of an affidavit this morning about getting into the consensual sex that Jane Doe number 2 had 3 days prior to the alleged rape. Now, getting into that arena, right? The judge is saying we may not need to call Jane Doe number 2 back to the stand, or even have the nurse. Y'all come up, both sides, with the stipulation to try and get that evidence in. If not, then we're going to have to recall these witnesses. The defense made the argument that stipulation, they kind of went towards this area of it's unlikely that we're going to be able to find a happy medium. Does the defense risk having Jane Doe number 2 come back, given the fact that she was so airtight and she gave Mark Carlos a run for his money?
Right. She was an excellent witness. I mean, she was compelling. She was just composed, very composed when she was asked questions on cross. I think you make a great point. They have to really do a risk assessment here and think, okay, is it worth it to hear it from her? Or should we just stipulate away to something we wouldn't ordinarily stipulate to, because we don't want to have her back on the stand? Because again, it's a reminder, primacy and recency. We say it all the time. In trial work, we want the best witnesses to be first, be last, and if she's going to come at the end of this trial again, that could be problematic.
Problematic indeed, because I think she could definitely handle herself in terms of
excellent.
Getting into that evidence. Thank you, Julie Grant.
My pleasure, Yodite.
All right, when we come back, testimony from the computer analyst who examined Winslow's Strava app. Welcome back. The prosecution says forensic evidence from Kellen Winslow's cycling app puts him outside Jane Doe number 3's house on the day she says a tattooed black man exposed himself to her. Let's listen to the testimony of the analyst who examined that app.
Now, you mentioned that there were various emails regarding Twitter activity. Can you describe what was located?
Again, one was from 2013, and it references using or starting cycling. Another was the fact that he tweeted, I just signed up for Strava.
And in terms of the user information for the Strava account, the email that stated "Welcome to Strava," was that sent to the K2 Gmail account that you just mentioned?
I'm not sure exactly which of the two email addresses it went to offhand, but it
was
to
one
one
of
of
the
those.
two?
Yeah.
Okay, and both of them noting K2, correct?
Right.
Now, in terms of any additional email artifacts or internet artifacts regarding cycling, what else did you locate?
There was some registration for USA Cycling, another email talking about having the first amateur road race or first amateur race in January of 2015. There were receipts for a variety of Stinner bicycles, an email referencing a couple specialized bikes, specifically a Venge and a Shiv TT, like a time trial bike.
So, Ms. Rosa, let me just ask you, are you familiar with cycling?
Yes, sir.
How are you familiar with cycling?
I ride.
What does that mean?
Well, I guess in 2012 I started riding a road bike. It was the first time I'd ever ridden. My husband got me into it. And so I used the Strava app, and I've just basically used it as a fitness tool. Having had previous knee injuries, it's a better tool for me than running is. So that's why I do it.
When you're referencing some of these bicycles, can you explain to the jury, in terms of the receipts and the emails that were obtained on this laptop, what type of bicycles are those?
So a couple of them were road bikes. The Venge and one of the Stinners would be a typical road bike setup. One was a mountain bike, that was one of the Stinners. The TT would be a time trial bike. Typically those are the ones that are more aerodynamic and have different wheel sets to make it basically faster.
And in terms of the app that you mentioned, you are personally familiar with the Strava app, is that correct?
Yes, sir.
What's the Strava application?
Objection. Foundation, permission before doing witness.
Establishing the foundation order.
Overruled. They were attempting to lay the appropriate foundation. You can answer if you know.
So Strava is a mobile app that can be used to track a person's activities, including cycling, running, hiking, kayaking, skiing. It basically records the GPS route that you take. There are people who have created segments, and so a lot of times the users will measure themselves against other people who have completed those segments. It also enables the person using it to see what their top 3 scores are and gives virtual medals for that. It enables basically some trophies for top 10 of the segments, including, King of the Mountain, Queen of the Mountain, if you're the top person on that particular segment, regardless of your age or weight or anything. It's just an overall.
Is the application itself, is that something that's put onto a device?
Yes, you could use it straight from your phone, or you can have some type of GPS, like a Garmin or Forerunner, and then you can sync it to the Strava app. Sometimes you could do it through Garmin Connect, and then it'll download and sync to the Strava app. You can access Strava on the internet as well. It doesn't just have to be on the phone to be able to see what your activities were.
And in terms of accessing it, does it actually have a automatically generated report of the user's activities?
Yes.
Now, when you've used the Strava application, can you just describe how you used it?
I've used it both from my phone directly and also from using Garmin's. So when you use it on your phone, you just open up the application and then you would hit the record button and it asks you what type of activity you want to record. Typically it's either like a run or a cycle or a swim for the first ones that you can choose. And so you choose which one you want, and then it shows a map and gives you basically the little blue beacon of where you are, and then you hit start and it will basically route as you ride or run. And then when you're done, you hit finish and it will compile all the data and show you the map, show your average time, show you the amount of miles you went, the time of day, whatever types of information you have set. And when you use a Garmin, you can obviously have more items to be retained, and you can have a power meter on your bike, you can wear a heart rate monitor, and it all syncs to give you a better overview of the work that you put in.
And in terms of the GPS coordinates that are being automatically recorded when the user essentially hits the prompt of record, is that something that's then stored on the application platform itself that could be accessible through the internet or through the user's device?
Yes.
And when that is being recorded, in terms of your experience with the app, how is it that Strava obtains the GPS location information for the user when they're recording a ride?
So from the phone, it would be from the location services enabled on your phone for that application. If you're using a Garmin, then it would be when you actually upload that to the computer. Like if you physically connect it, all of the information is stored in that Garmin file, and then the GPS file that's on that Garmin, and then it would sync and upload.
In terms of your training experience as a forensic examiner, are you familiar with cell phone GPS technology?
Yes.
Can you just explain how a cell phone is able to be located in a particular geographic area based on GPS data?
Well,
It may be common sense at this point, but if you can explain based on your experience.
Well, whatever I use it for, it's basically for maps, for directions, for Strava, and so my location services are enabled on my phone for those particular things, and so it will hit the various satellites to show me where I'm at, basically.
And is that the same technology that's used for the Strava application?
Yes.
All right, we expect to hear more crucial testimony today. Scheduled to testify are Jane Doe number 1's daughter and Jane Doe number 4, the young woman who accused Winslow of raping her almost 16 years ago. Stay tuned to CourtTV Live.
Kellen Winslow II, an NFL star.
You immediately knew that people were going to pay attention.
There are 5 different women who are accusing him of being a serial sex offender.
You will hear from each one.
He goes, if you don't do this, I'm going to kill you.
Winslow denies all charges and claims the women are just after his money.
This is a part of the story that is getting unusual, to say the least.
It's very hard for us to put ourselves in the criminal mind.
Good morning. This is CourtTV Live. I'm Yodite Tewolde. In just an hour, the jury is going to hear a big day of testimony in the Kellen Winslow rape trial. We're expecting testimony from Jane Doe number 1's daughter after the judge made a key ruling in favor of the prosecution, and Jane Doe number 4, who claims she was raped by Winslow in 2003. She'll also take the stand. All right, let's head straight out to San Diego County Courthouse. That's where CourtTV legal correspondent Chanley Painter is standing by. Chanley, hello. Thank you for being with me. All right, so big day, 9 a.m. It's about to get started in about an hour. Are you seeing people kind of already crowding the courthouse right now? I mean, given the fact that we are finally going to be hearing from Jane Doe number 4 and Jane Doe number 1's daughter.
There is a steady flow of people into the courthouse this morning. It's a busy courthouse. In fact, the traffic line was backed up to pull into the parking lot this morning. Don't know if it's for this trial or for many other issues that might be happening in court today. But we do see, family and friends and attorneys arrive probably about 15 minutes before court actually starts this morning. So we'll be on the lookout for those who arrive. We can expect to see Kellen Winslow Sr. walk into the courtroom as he's been every day, as well as other friends and family and the attorneys. Yodite?
Chanley, we talked before about the defense team being one, there was a big group effort, the attorneys, Kellen Winslow involved in his case, writing copious notes, and also the people behind him, the 2 rows that are reserved for family and friends. And they had a pretty good day after Jane Doe number 1 testified. What about their reaction? Can you tell us from inside the courtroom yesterday when the judge said that he was going to allow Jane Doe number 1's daughter to testify?
It was kind of like the air went out of that section of the courtroom. It was deflating. It was disappointing to the defense team that the judge allowed her to testify. Mark Carlos fought fiercely in front of the judge saying, look, it's like if she was sitting here in the courtroom watching the whole trial and saying, oh yeah, I remember this. She watched it all on the news. Her testimony is tainted. And the judge said, well, that might be so, but you have wide latitude to cross-examine her about that on the witness stand so the jury will know exactly and be able to judge that credibility. Is she biased? Does she have a motive to help her mother? Is what she's saying even true or not? So we should expect a pretty ardent cross-examination by Mark Carlos today of Jane Doe number 1's daughter.
And what about the testimony about the Strava app, placing Kellen Winslow outside of Jane Doe number 3's house the day before and the day of the alleged, where he allegedly exposed himself to Jane Doe number 3. What was the reaction from the jury hearing that testimony come out?
That was a big issue yesterday, but you know what, Yodite, the jury wasn't in the courtroom for a lot of the fight on whether or not that was going to be allowed in or not. So really, as they sit there, it was like any other testimony they were hearing all day long because they didn't know that the defense really didn't want that information in there or the prosecutor was fighting to keep it in there. It was just like another witness on the stand testifying, and as we saw yesterday, Dan Owens introduced it through one witness, and then the next witness actually put the maps on the screen, and they were noting, the routes that he was taking, and Dan emphasized that the location started on the same street as Jane Doe number 1, and one of the routes even was the same route as Jane Doe number 2 alleges that Winslow took her on. And so I'm really impressed with this jury because they're taking a lot of notes. I take a lot of notes, but they're taking way more than I am.
As they should be. There's a lot of Jane Does involved. Okay, Chanley, one last thing. Do you know how far we're going to get into Jane Doe number 4's case? I know we're supposed to be hearing from Jane Doe number 1's daughter first. Is there any chance that we could possibly hear more than just Jane Doe number 4 testifying today?
It is possible, Yodite. We know that she told at least 3 people about what allegedly happened to her in 2003. We can expect, though, that her testimony will take a while. We can expect another fierce cross-examination of Jane Doe number 4. They'll really try to get at her credibility, but we'll probably hear first from her friend, if there is time today, Nikki Edwards, the fresh complaint, who she told the night that it happened back in 2003. And that's an important witness, Jody, because this jury will also have to decide a kind of a bifurcated issue under the law, because this is from 15, 16 years ago. To toll the statute of limitations, the jury has to decide whether or not the testimony of Nikki Edwards is independent corroborating evidence enough, beyond clear and convincing evidence, to toll the statute of limitations. So that's an interesting angle to this testimony. That will all be explained to the jury in a jury instruction.
As usual, great insight. Chanley Painter out in San Diego, thank you so much. All right, a lot has happened in the first 5 days of this trial. Let's take a look back at some of what has happened yesterday in the courtroom.
Did they ask him, did he clean any bodily fluids out of the car?
None of them spoke with him.
Did you find any blood in the car?
I did not find any blood in the car, no.
And is that the front passenger seat?
Yes.
Did you swab the seat cushion areas, or did you simply swab the seat belt itself?
I did not swab the seat cushion areas, just the seat belt latch.
Did you swab any areas visible here for potential DNA?
Other than the seatbelt buckle and latch, no, I did not.
Does the record show that Mr. Winslow was riding his bike on May 24th, 2018, around the time that's alleged for count 6?
Yes, Your Honor. It shows that he began a ride at 3:26 p.m. and the ride origin is just approximately one house away from where the victim stated this occurred.
The people contacted Strava and served them with a search warrant, and in reply, the representative from Strava said that they were completely unable to locate any records.
So they're objecting that it's A, hearsay, and B, the lack of foundation. And so the prosecutor is trying to get around that. He just got served with this motion this morning, but he's trying to get around it by asking these computer expert witnesses about their familiarity with how they track this data. Because if it is GPS based, we know that GPS based information is not hearsay, and therefore they could testify to that.
Didn't you say that the witness said her husband got her into using the Strava app?
Right, yeah, she's an avid cyclist. So
Why is that even coming into evidence? Why is she even allowed to say that?
because she did. Nobody objected. I didn't hear an objection. Did anyone hear an objection?
No, we didn't hear any objections, Vinny. Exactly, and they should have been standing up and objecting to this.
Was there in fact a DNA swab kit from the front passenger door panel?
Yes.
And were you able to obtain any DNA that matched Mr. Winslow?
Yes. That was an apparent single source DNA profile that appeared consistent with DNA from Winslow.
Okay, well, imagine your investigator asked her about what she watched and what she saw. And I don't know of any case or any statutory authority that would say that this witness is completely barred from testifying. So she will be able to testify. And Mr. Carlos, you can cross-examine her as much as you want as to what she saw, what talking heads she listened to, and what she heard her mother say while she was watching TV. I am not restricting you in any way in that cross-examination. I just don't see any authority for barring her.
So much to unpack. So with me now to unpack our criminal defense attorneys, Ashley McMahan and Michael Sterling. There is a lot going to happen today. You know, a lot of yesterday's testimony was very scientific. Could have put the jury asleep at some point. A lot of the heated debates happened outside of their presence, but they're about to be exposed to a lot of testimony that's going to be pretty interesting. Jane Doe number 1's daughter and Jane Doe number 4, possibly her husband, her ex-boyfriend, and her friend. But before we get into that, this Strava app, I'm not a cyclist. I don't know if you guys are. I never heard of Strava until today or yesterday. Okay, so am I tripping? The Strava app info should not be coming in through anyone other than a Strava employee, a custodian who can actually go on the stand, as custodian of record, go on the stand and say, this is what this app is about. This is accurate information. Because these are screenshots that were taken.
Ashley would have objected. She would have never let that come in.
Exactly.
So you had
this is why I love you, Michael.
So you had a problem with the defense not objecting?
Oh, yes. And I mean, you lose all of the objections that you don't make. I mean, that's rule number 1.
But how important is it for objections to be made, even though you know what the judge may rule? How important is that to communicate with the jurors?
It's important not only to communicate with the jurors, because you want to sort of get that on the record, but it's important for the record itself because you may need it as a basis for appeal. So you want to make sure you're creating a clean record. You can't appeal things that you did not object to. If you let it come into evidence, lawyers can make fundamental errors by not, making those critical objections. And if you find that jurors use this information to convict them, you now have no basis for appeal because you failed to object.
That's a good point. That's an excellent point, actually. Okay, so what are y'all looking forward to seeing today? Jane Doe number 1's daughter is going to be taking the stand. Then you have Jane Doe number 4, who made an accusation about an alleged rape that took place in 2003, so 16 years ago. What are y'all looking forward to seeing most from those that are going to be testifying today?
I would hope that, I don't know if the defense team is going to do this, but I would hope that they would take Jane Doe number 1's daughter on voir dire even before the prosecution is able to get a direct exam. I think the judge should allow that because I think maybe the defense team can lay enough, they should be able to take her on voir dire outside the presence of the jury and have a conversation about what she saw, what she did or didn't do, get that on the record, and maybe, create something that gets the judge to dismiss her testimony altogether. I think the judge should allow them the latitude to take her on voir dire even before the direct and cross-examination.
Because they just found out about this Thursday afternoon. Right. Court was not in session last Friday. Monday was a holiday. Tuesday was the hearing in which to address this, and the judge says she could go ahead and testify. So they haven't had an opportunity to actually vet her, right? So Ashley, you agree?
Oh, I agree completely with Michael. And also, I think it's just going to be exciting today to see what type of witness she is. I mean, whether or not the prosecution is even going to be able to control her on the witness stand. I mean, when you've got a witness coming in the middle of the game here, okay?
Yeah.
In the last hour, I mean, she's liable to say anything on the stand, and it may or may not help the prosecution's case. This witness could backfire on the prosecution.
And it completely upends sort of the general rules of engagement when you're going through trials. I mean, there are discovery rules in place for a reason.
Yeah.
You're supposed to have access to all of the witnesses' information. You're supposed to know what they're going to say. You're not supposed to be able to have a trial by ambush, right? The judge instructs the jurors and others, instructs the jurors, you're not supposed to watch television because you don't want it tainted. You invoke the rule as a defense lawyer so that individuals who are going to testify can't fashion their testimony off what other people say. And now you've got a witness who wasn't a part of any discovery, who has been watching the news, who's been watching gavel-to-gavel coverage here on CourtTV.
Hey, gavel-to-gavel.
and who could essentially fashion her testimony in a way that benefits the prosecution, and it's unfairly.
Unfairly, yes, but they didn't know about her. So if they don't know about her, they can't necessarily, have all those rules apply. But I guess. Okay, you guys are going to be standing by. All right, coming up. Was Kellen Winslow trying to get rid of evidence when he put his Hummer up for sale in the days leading up to his arrest? More on that after the break. Welcome back to CourtTV Live. Okay, the prosecution alleges that in the week leading up to his arrest, Kellen Winslow had his Hummer cleaned and put up for sale. Here's forensic digital analyst Haley McKinney explaining how she extracted that information from Winslow's phone.
And in terms of the content of the text message, what was that first text message that was outgoing from the phone that you downloaded?
It says, Roman, what's up, bro? How have you been?
And was that sent on June 7th, 2018 and delivered to that phone number?
Yes.
What was the next text message sent by this phone, for the user of this phone, on June 7th at 2:53 p.m.?
It says, want to sell this Hummer.
Was there a response that was received a minute later?
Yes. It says, K2, how are bro?
And was there a additional text sent at 4:51 p.m. or 16:51?
Yes.
On June 7th?
Yes, there was.
And was that a incoming text to the device that you downloaded?
Yes, it was.
Was there a name associated with the phone number that sent this text?
Yes.
Is it listed in parentheses?
It is.
And what's that name?
Roman.
Does that come from the contact list from the device that was downloaded?
Yes, that's correct.
And what was the content of that further text message now later in the day on June 7th?
It says, K2, can you text me some pics of your truck with the VIN number and mileage?
Was there a additional text sent at 5:35?
Yes.
What was that?
It says, I would like to buy it to tow some jet skis.
Were there further texts regarding a potential purchase of the Hummer?
Yes.
What were the additional texts?
Continue, it says, you only thinking about a Raptor? And then continues, K2, how soon do you want to sell the Hummer?
Were each of those sent on June 7th, 2018?
Yes.
As far as you know, based upon your knowledge of the investigation, was that the same date that Mr. Winslow had been contacted by law enforcement and a reference sample of DNA was obtained, yes or no?
Yes.
Now, we were just discussing the conversation regarding the negotiation and purchase of a Hummer H2, is that right?
Yes.
Looking at that exhibit before you on Court's Exhibit 148, does that show that there was a series of photographs that were taken of the black Hummer H2?
Yes.
What was the date that the first photograph was taken?
June 9th, 2018, approximately 3:23 in the afternoon.
And does this first exhibit show 7 total photographs? I can't count correctly today, 6 total photographs.
Yes, it does.
Showing you further, Court's Exhibit 149, does it show a series of photographs also taken on the same date?
Yes.
And were those various locations on the Hummer H2?
Yes.
Showing you Court's Exhibit 150 for identification, does that continue to show a series of photographs taken on June 9th?
Yes, it does.
And do they all depict various locations within the Hummer H2?
Yes, it does.
Showing you Court's Exhibit 151, for identification, does that likewise show different locations within the Hummer H2?
Yes.
And were those taken on the same date of June 9th?
Yes, they were.
And showing you Court's Exhibit 152, were those additional photographs taken of the interior portion of the Hummer H2?
Yes, they are.
And were they also taken on the same date of June 9th?
Yes, they were.
Now showing you Court's Exhibit 153 for identification, does that show the last of the series of photographs taken of the Hummer H2?
Yes.
And were they all taken on the same date?
Yes, they were.
Thank you, nothing further, Your Honor.
All right, Cross.
Thank you. Good afternoon, Ms. McKinney.
Hi.
Can you hear me from here?
I can.
Thank you. You just testified to a series of text messages between Kellen's iPhone and a person identified as Roman.
Yes.
Are you aware that Roman is a licensed car dealer?
I was not.
Did you do any investigation into who Roman is?
I do not recall specifically. I do know there was some discussion with one of the detectives in the unit, but I think he did most of it on his own.
So another detective did the investigation into who Roman is?
Correct.
Do you know who that detective is?
Detective Sean Snow?
Snow?
Yes.
So these conversations, this text series between Kellen's iPhone and Roman began on June 7th. Is that right?
Let me just go back to the exhibit here. Yes, that's correct.
And the two individuals are talking about the sale of the Hummer on June 7th, June 7th.
Correct.
Right? June 8th.
I do not have text messages on June 8th for that.
June 9th.
Yes.
June 10th.
Yes.
And June 11th.
Yes, that's correct.
And was there anything in that series of text messages that indicated any urgency to sell the Hummer?
Not that I saw.
All right, back with me now to discuss our criminal defense attorneys Ashley McMahan and Michael Sterling. And joining us from San Diego, again, is Gretchen Von Holmes. Gretchen, so clearly the state is trying to imply that Kellen Winslow was trying to get rid of some damning evidence, being the Hummer. The Hummer is what was alleged to, that he used in picking up Jane Doe number 1 and 2, and trying to sell it. How damning do you think that is for the defense, or is it? Does it matter?
Well, he's entitled to sell the vehicle, obviously. The question is the timing, and that's what the prosecution is going after. They're trying to indicate, well, he must have had it all cleaned up because he was trying to get rid of some DNA evidence in that Hummer that may have verified if those women were indeed in that vehicle.
Mm-hmm. Well, I mean, if there's no DNA found inside, why does it matter? And does it suggest that the investigation is not necessarily as thorough, being that no one really talked to Roman, the person that Kellen Winslow was texting about selling the vehicle?
Right, that's the point of the cross-examination is, A, there was no DNA, no one's followed up on this. They're just trying to speculate and guess that this may have been his motive. And so the defense will make a good argument of that in their closing argument. Right now, they're just kind of showing that the prosecution may have been kind of sloppy about it, may have, it took them a while to file charges after these allegations came forward.
All right, in-studio guest. Okay, so we didn't see a clip of this, but this Haley McKinney, the forensic digital analyst, was able to extract information from Winslow's cell phone, an iPhone 7. And he appeared, Winslow, to have conducted several searches. how do men show their bulge?
Oh, no. Just.
Why are we quiet? What? It's just a mountain of just circumstantial evidence on top of circumstantial evidence. Why would anybody Google how to show your bulge if you're not showing your bulge to Jane Doe number 3 and 5?
Yeah, but showing your bulge and exposing yourself are very different things. I think, you know, as a criminal defense attorney, you've got to.
Man, you're good.
You've got to get into the details. You know, I'm sure that there are ordinary men. I'm sure that there are ordinary men out there.
But okay, so if you're trying to show your bulge, but you're not necessarily exposing yourself, if we're thinking about the logic you're implying here or trying to employ, what's next though? Why just stop there, right? It's come on. It doesn't make any sense. These jurors have to use common sense at this point. It's gonna be like, okay, I know you guys want the CSI effect. Sure. I know it's really good stuff that you're getting to hear that Strava, this app, is putting Kellen Winslow right there in front of Jane Doe number 3's house. They love that stuff, right? But a lot of this is really just common sense, Ashley.
Yes, I would agree.
I mean,
yes, I mean.
Okay, the Strava app,
Yes.
CSI effect. How important is that? Because sometimes that can be a struggle for us former prosecutors, right?
Sure.
For us to prove our case, because they're always expecting that CSI effect. TV does this, right?
Yes.
So how important and how much weight are they going to put on that app?
Oh, I think the jury is going to eat that evidence up. I think they're going to love it. This is exactly what they're looking for. I mean, now you've got a GPS location that puts him in the exact location that he said he wasn't. You know, he's got this argument that this situation with Jane Doe 3 never happened. Yeah. And then here he is on a GPS location right there. I'm sorry, but that is bad for the defense. This one's rough.
I think the defense, they need to call someone from Strava. They need to, in their case in chief, they need to get someone on Strava on the stand to sort of explain what they were explaining outside the presence of the jury to the judge about the inaccuracy of the app, about them not being able to track it, so that if you have somebody from Strava competing against a computer expert who had nothing to do with Strava, if you have somebody from the actual app company that can explain that, it may really help the defense's case in chief.
We're gonna see. As usual, you guys are not going anywhere. All right, we're gonna have to take a short break, but when we come back, more testimony from John Johnson, the lead detective during the investigation of Kellen Winslow. Stay with us.
I'm Julie Grant. As a lawyer, I'm an officer of the court. As a prosecutor, I represented the people. Now on CourtTV, I represent you.
You have to look at everything in this case.
Because it's my job to bring you the whole truth and nothing but the truth.
The all-new CourtTV, your front row seat to justice.
You're watching CourtTV. I'm Yodite Tewolde. The detective who led the investigation in the Jane Doe number 1 and 2 cases testified Tuesday that in the Kellen Winslow rape trial. Let's dive back into what Detective John Johnson said on the stand.
Detective Johnson, we've heard your name quite a bit over the course of the last week, but now we want to hear from you in terms of some of the follow-up investigation you did into the reported rapes that had occurred in the spring of 2018, and as well as a indecent exposure incident that happened on May 24th of 2018. Is it fair to say that you became the primary investigator into those offenses from the Sheriff's Department Sexual Assault Unit?
That would be fair.
When was it that you first became involved in this investigation?
On May 14th of 2018, I received a call out of a sexual assault examination, and that would be involving Jane Doe 2.
Was your first direct participation in that investigation when you responded to the sexual assault exam at the hospital?
At the SART facility, yes.
Did you, in fact, arrive after Nurse Ann Williams had already begun her sexual assault examination?
I arrived after the interview part was in progress, yes.
Were you briefed on the information that had been developed, at least as of that point in time, by the area detectives who were involved?
Yes.
Did that include Detective Adrian Moses?
Yes.
Did he inform you that a suspect had been identified at that point?
Yes.
And was that pursuant to a photographic lineup administered to Jane Doe number 2?
That's what they told me, yes.
Once you had that information, did you in fact seize evidence following the sexual assault exam that was conducted with Jane Doe 2?
I seized the sexual assault kit, the forensic kit that they collected a couple days later when it was processed by them.
In terms of the chain of custody process for the collection of the sexual assault kit, can you explain to the jury what you did?
I went to the facility. This particular facility was in Escondido, and met with Julissa, I believe that's Julissa, one of their clerks. And she went to the recesses of the facility and brought out paper sacks that were taped and sealed and initialed, and printed out a report and some paperwork, and I signed for that and took it away.
Is that the standard protocol from the Sheriff's Department Sexual Assault Unit in the collection of a SART kit?
That's pretty standard, yes.
Did you in fact receive the SART kit and book it into evidence under case ending 974 of the Sheriff's Department?
Yes, I did.
Did you submit any requests from the Sheriff's Department Crime Lab in relation to that SART kit?
Yes, when we impound a SART kit, we're actually required to request labs on the kit to get the process started.
And did you do so in this case?
Yes, I did.
Did you request DNA analysis of the items that had been seized and sealed within those evidence collection bags or the kit itself?
I asked them to develop a DNA profile and analyze it if they possibly could, certainly.
Now, in addition to the collection of the SART kit itself and the request for any DNA analysis, did you attempt to conduct some initial follow-up investigation by speaking with Jane Doe 2 herself?
Oh, certainly.
And at least in terms of when you spoke to Jane Doe 2, what date was that?
Well, during the SART exam, I listened to as much of the story as I was present for and asked her follow-up questions. That would have been May 14th.
And going forward in the weeks that followed, once you had a suspect identified in that photographic lineup, did you attempt to continue to investigate the case?
Yes.
On May 24th of 2018, did you receive information about another crime that had occurred in the city of Encinitas involving a person who matched the description for your case?
Yes, I did.
What information did you receive and how?
I know that a report was assigned to me, and I believe that I received a phone call from the area sergeant in the North Coastal Station informing me that indecent exposure had been reported, and they thought maybe I would wanted to look into that.
Did that incident, or was that reported incident, did it take place on Lake Drive in the city of Encinitas?
Yes.
Were you aware of the address associated with the suspect, Kellen Winslow, that you were investigating? Yes or no?
Yes.
Was that residence also on Lake Drive?
Yes.
What did you do based upon the information that was given to you initially about the indecent exposure incident on May 24th?
Well, I read the report that that the deputy took. I, at some point, watched his body-worn camera footage, and at some point, I went out and spoke with the reported victim of that crime.
And is that a person who we're referring to as Jane Doe number 3?
That would be correct.
I got my defense attorneys on deck, Ashley McMahan and Michael Sterling, and out in San Diego, Gretchen Van Holmes. Okay, Gretchen, the investigator here, the detective, He talked about investigating Jane Doe number 2 and speaking to the SART nurse, the sexual assault rape test nurse. And he talked about how we didn't get to see that clip, but he did testify on cross-examination that Jane Doe number 2 told him when he got this report and he spoke to her, told him that the anal penetration could have been an accident, or might have been an accident. Tell us why intent doesn't necessarily matter when you're trying to establish forcible sodomy in California.
Well, the reason why is it's a slight penetration of the anus, and so it doesn't have to enter like into the anal cavity. It can just penetrate that fold. It's around the anus, and so any penetration of the anal area can, withstand on appeal that conviction.
Yeah, why do you think in cross-examination, we didn't get to see that clip, but cross-examination they were harping on the fact that this could have been an accident, as if forcible sodomy couldn't have occurred because this was an accident?
Well, what they were trying to show, because a lot of people are pretty disgusted by anal sex, right? And there's going to be a visceral reaction from the jury. So if you're going at someone vaginally from the rear and you miss and you touch the anal area on accident and then resume trying to get into the vagina, I think they were trying to, not necessarily go after the exact legal definitions there, but just for the jury appeal to have that not be forced anal sex, intentional forced anal sex.
So if the anal sex wasn't forced, then possibly
because
the
that
vaginal,
kind of, right.
Then the vaginal sex wasn't forced, essentially is what
Right.
they're trying to get at. Okay, gotcha. All right, so you guys in here with me. So Detective John Johnson, he investigated Jane Doe number 2 and 3, and at the end of that clip, we hear that he watched a body cam video, which of course had Jane Doe number 3 testifying in the video as to what this perpetrator may have looked like. If we could run that clip.
We'll start with what he looked like. Did he have like an afro, shaved head? Does his hair look like mine?
His hair, so
Short hair?
like that, and curly. He had curly. Curly.
Did he have any tattoos on his face?
Oh, he tattooed a hand.
Which hand?
2 hand.
He had tattoos on both hands? He had two full-on ones?
Sleeves.
Like mine? Like those?
I think just only no color.
No color? Black and white?
I think blue.
Blue? Okay.
Two hand.
All right, so that was what we got to watch with Jane Doe number 3, because at first we just had the sound of her on the body cam, but now we actually get to see her, not her face, of course, we're trying to protect her privacy, but her husband as well sitting there, and she's describing this perpetrator as having curly hair and blue tattoos. Now we know that Kellen Winslow does not have blue tattoos, but this is her describing yet again somebody other than Kellen Winslow. So do you think that makes much of a difference that he has green tattoos versus blue, Ashley?
I mean, I think that her entire testimony, whenever she describes him, makes a huge difference to the jury. Because, I mean, he's what, 6'4", 6'5"?
And she said he was 5'8",
She said he was
5'9".
5'8" or 5'9". That's a big deal.
Yeah.
I mean, she did kind of, walk back her testimony and saying that, look, I'm Vietnamese, in my culture, I don't look at people's faces that much, but you should be able to tell the difference between somebody who's 5'8", 5'9", and 6'4", 6'5",
Okay, Michael, is this fair? What if she was gardening at the time? She did claim that that's, what she was doing. And she was kneeling and looked up and may have thought at that point, I mean, come on, 5'8", 5'9", I can't even guess how tall you are. I don't know. So saying that versus, hey, he's got 2 sleeves, and we know Kellen Winslow does have sleeves.
Yeah. I mean, whatever it is, if identity is going to be an issue in this particular case, you've got to hone in on that. So if she's going to have trouble identifying his face, identifying his height, identifying, his build, whatever it is, the defense is just going to have to hone in on it, that you don't convict somebody on maybes. You don't convict somebody on possiblies. You convict individuals on beyond a reasonable doubt. And if there's any question to his identity, however you get to that point, whether she was kneeling, however it is, you cannot convict Kellen Winslow on that particular account if there's an identity issue. And so however you get there with her having trouble to specifically identify Kellen Winslow as the perpetrator.
Yeah. Okay, well, Gretchen, back out to you. Do you think this detective was helpful in his testimony? I mean, he was the one that was really the only person to make the connection between Jane Doe number 1, 2, 3, but kind of seemed uninterested and kind of aloof in court. Did he help?
Yes, I think it did help because it kind of shows that these victim witnesses, 1 and 2, may not be that credible. One is a hitchhiker, the other person's homeless. You know, they have issues with, you know, why they're homeless, mental health issues, drug issues, potentially. And so the jury's going to see all that, and they're going to see that this police officer was not that enthusiastic maybe about, you know, bolstering their credibility. And so that does say something to the jury.
Yeah. I mean, it's all about presence, right? And I think at the beginning, before I forget this point, because at the beginning of the clip, we did see a Kellen Winslow kind of put his hands up in the air in that mashup. Not with the Detective Johnson, but before that, in the mashup of where this case is 5 days later, we did see him throw his hands up in one of the clips, and we both looked at each other, right? Yeah. How important is it as criminal defense attorneys for us to make sure that we prep and admonish our clients in terms of how they look in front of a jury? Because jurors are so perceptive and they pick up on everything. But then again, I do remember my days as a criminal defense attorney. I used to do things on purpose to be able to communicate with the jury, whether that's facials, hands up, hey, that person's lying, gotta let you know. So Kellen Winslow throwing his hands up, a raw reaction, or do you think it's something that was rehearsed and maybe done on purpose?
I think it was a raw reaction.
Yeah.
But again, you know, just like you were saying, it's all about the optics with your client on this. You know, you've got to sit down with them. You've got to basically coach them through, hey, you're going to hear things on the stand that you're going to disagree with. Don't react unless, you know, you're looking for that reaction. But it's too, in my opinion, it's too difficult to train any sort of client who's sitting through a trial to make the right gestures and the right facial expressions at a certain time.
And I think that's why he's doodling a lot. I mean, I don't think he's really writing. When you really watch his pen, it's not going from left to right. It's like literally staying in the same spot. So
I do that to clients. I put a pen in their hand and say, if you've got to react, write it down. If you feel angry, scratch something on the paper.
Or just look down,
right? Yeah, just look down. Yeah. Don't react. I will react enough for the both of us. I will be exacerbated by the outrageousness of somebody's testimony. You don't do that, though. You stay focused.
Yep, absolutely. Awesome legal panel. Thank you so much.